D. If a standby specifies that a signature must be made by a named natural person without requiring that the signer's status be identified, a signature complies that appears to be that of the named person, a named legal person or government agency without identifying who is to sign on its behalf or its status, and any signature complies that appears to have been made on behalf of the named legal person or government agency, or a named natural person, legal person or government agency requiring the status of the sig- signer to be signer be indicated. A signature complies which appears to be that of the named natural person, legal, government or governmental agency and indicates its status. Demand document implied. If a standby does not specify any required document, it will be deemed to require a documentary demand for payment. 4.09 Identical ordering and quotation mark. If a standby requires a statement without specifying precise ordering, then the ordering in the document presented must appear to convey the same meaning as that required by the standby. B. Specified ordering by the use of quotation marks, blocked ordering or an attached exhibit or form, then typographical errors in spelling, punctuation, spacing or the like that are apparent when read in context are not required to be duplicated, and blank lines or spaces for data may be completed in any manner not inconsistent with the standby. Or specified ordering by the use of quotation marks, blocked ordering or an exhibit or an attached exhibit of form, and also provides that the specified ordering be exact or identical. Then the ordering in the documents presented, including typographical errors in spelling, punctuation, spacing and the like, as well as blank lines and spaces of data, must be exactly reproduced. Applicant approval. A standby should not specify that a required document be issued, signed or countersigned by the applicant. However, if the standby includes such a requirement, the issuer may not waive the requirement and is not responsible for the applicant's withholding of the document or signature. 4.11 Non-documentary terms or conditions. A standby term or condition which is non-documentary must be disregarded whether or not if it affects the issuer's obligation to treat a presentation as complying or to treat the standby as required, amended or terminated. B. Terms or conditions are non-documentary if the standby does not require presentation of a document in which they are to be evidenced, and if their fulfillment cannot be determined by the issuer from the issuer's own records or within the issuer's normal operations. C. Determinations from the issuer's own records or within the issuer's normal operations include determinations of when, where and how documents are presented or otherwise delivered to the issuer, when, where and how documents affecting the standby are sent or received by the issuer, beneficiary or any nominated person, amounts transferred into or out of accounts with the issuer, and amounts determinable from a published index, e.g., if a standby provides for determining amounts of interest accruing according to the published interest rates. An issuer need not compute a beneficiary's computations under a formula stated or referenced in a standby except to the extent that the standby so provides. Formality of statements in documents. A required statement need not be accompanied by a solemnity officialization, or any other formality. If a standby provides for the addition of a formality to be required statement by the person making it without specifying form or content, the statement complies if it indicates that it was declared, averred, warranted, attested, sworn under oath, affirmed, certified, or the like. C. If a standby provides for a statement to be witnessed by another person without specifying form or content, the witness statement complies if it appears to contain a signature of a person other than the beneficiary with an indication that the person is acting as a witness. If a standby provides for a statement to be countersigned, legalized, decided, or the like by a person other than the beneficiary acting in a government, judicial, corporate, or other representative capacity without specifying form or content, the statement complies if it contains the signature of a person other than the beneficiary and includes an indication of that person's representative capacity and the organization on whose behalf the person has acted. No responsibility to identify beneficiary, except to the extent that a standby requires presentation of an electronic record. A person honoring a presentation has no obligation to the applicant to ascertain the identity of any person making a presentation or any assignee of proceeds. Payment to a named beneficiary, transferee, an acknowledged assignee, successor by operation of law, to an account or account number stated in the standby or in a cover instruction from the beneficiary or nominated person fulfills the obligation under the standby to that effect payment. Name of acquired or merged issuer or confirmer. If the issuer or confirmer is reorganized, merged, or changes its name, any required reference by name to the issuer or confirmer in the documents presented may be to it or its successor. 4.15 Original copy and multiple documents. A presented document must be an original. Presentation of an electronic record where an electronic presentation is permitted or required is deemed to be an original. A presented document is deemed to be an original unless it appears on its face to have been reproduced from an original. A document which appears to have been reproduced from an original is deemed to be an original if the signature or authentication appears to be original. A standby that requires presentation of a copy permits presentation of either an original or copy, unless the standby states that only a copy be presented or otherwise addresses the disposition of all originals. E. If multiples of the same document are requested, only one must be an original unless duplicate originals or multiple originals are requested, in which case all must be originals, or two copies, twofold, or the like are requested, in which case either originals or copies may be presented. Standby document types. Demand for payment. A demand for payment need not be separate from the beneficiary statement or other required document. If a separate demand is required, it must contain a demand for payment from the beneficiary directed to the issuer or nominated person, a date indicating whether the demand was when the demand was issued, the amount demanded, and the beneficiary's signature. A demand may be in the form of a draft or other instructions, order, or request to pay. If a standby requires presentation of a draft or bill of exchange, that draft or bill of exchange need not be in negotiable form unless the standby so states. Statement of default or other drawing event. If a standby requires a statement, certificate or other recital of a default or other drawing event and does not specify content, the document complies. If it contains a representation to the effect that payment is due because a drawing event described in the standby has occurred, a state indicating when it was issued, and the beneficiary's signature. 4.18 Negotiable documents. If a standby requires presentation of a document that is transferable by endorsement and delivery without stating whether, how, or to whom endorsement must be made, then the document may be presented without endorsement. Or if endorsed, the endorsement may be in blank, and in any event the document may be issued or negotiated with or without recourse. 4.19 Legal or judicial documents. If a standby requires presentation of a government-issued document, a court order, an arbitration order, award, or the like, a document or a copy is deemed to comply if it appears to be issued by a government agency, court, tribunal, or the like, suitably titled or named, signed, dated, and originally certified or authenticated by an official of a government agency, court, tribunal, or the like. 4.20 Other documents. If a standby requires a document other than one whose content is specified in the rules without specifying the issuer, data content, or wording, a document complies if it appears to be appropriately titled or to serve the function of that type of document under standard standby practice. D. A document presented under a standby to be examined to the extent of standby practice under these rules, even if document is of a type such as a commercial invoice, transport document, insurance documents, or the like, for which the Uniform Customs and Practice for Documentary Credits contains detailed rules. Request to issue separate undertaking. If a standby requests that the beneficiary of the standby issue its own separate undertaking to another, whether or not the standby recites the text of that standby of that undertaking, the beneficiary receives no rights other than its right to draw under the standby, even if the issuer pays a fee to the standby for issuing the separate undertaking. Neither the separate undertaking nor the documents presented under it need not be presented to the issuer, and if originals or copies of separate undertaking or documents presented under it are received by the issuer, although not required to be presented as a condition to honor of the standby, 1. The issuer need not examine and in any event shall disregard their compliance or consistency with the standby, with the beneficiary's demand under the standby, or with the beneficiary's separate undertaking, and the issuer may without responsibility return them to the presenter or forward them to the applicant with the presentation. Rule 5. Notice, preclusion and disposition of documents. Timely notice of dishonor. Notice of dishonor must be given within a time after presentation of documents which is not unreasonable. Notice given within 3 business days is deemed to be not unreasonable, and beyond 7 banking days is deemed to be unreasonable. Whether the time within which notice is given is unreasonable does not depend upon an imminent deadline for presentation. 3. The time for calculating when notice of dishonor must be given begins on the business day following the day of presentation. Unless a standby otherwise expressly states a shortened time within which notice of dishonor must be given, the issuer has no obligation to accelerate its examination of a presentation. The means by which a notice of dishonor is to be given is by telecommunication, if applicable, and if not, by another means which allows for prompt notice. If notice of dishonor is received within the time permitted for giving the notice, then it is deemed to have been given by prompt means. Notice of dishonor must be given to the person from whom the documents were received, whether the beneficiary, nominated person, or person other than a delivery person, except as otherwise requested by the presenter. Statement of grounds for dishonor. A notice of dishonor shall state all discrepancies upon which dishonor is based. Failure to give timely notice of dishonor. Failure to give notice of a discrepancy in a notice of dishonor within the time and by the means specified in the standby or these rules precludes assertion of that discrepancy in any document containing the discrepancy that is retained or represented, but does not preclude assertion of that discrepancy in any different presentation under the same or a separate standby. Failure to give notice of dishonor or acceptance or acknowledgement that is deferred payment undertaking has been incurred obligates the issuer to pay at maturity. Notice of expiry. Failure to give notice that a presentation was made after the expiry date does not preclude dishonor for that reason. 5.05. Issuer request for applicant waiver without request by presenter. If the issuer decides that a presentation does not comply, and if the presenter does not otherwise instruct, the issuer may, in its sole discretion, request the applicant to waive non-compliance or otherwise to authorize honor within the time available for giving notice of dishonor, but without extending it. Obtaining the applicant's waiver does not obligate the issuer to waive non-compliance. 5.06. Issuer request for applicant waiver upon request of presenter. If after receipt of dishonor of notice, a presenter requests that the presented documents be forwarded to the issuer or that the issuer seek the applicant's waiver, no person is obligated to forward the discrepant documents or seek the waiver, seek the applicant's waiver. The presentation to the issuer remains subject to these rules unless departure from them is expressly consented by the presenter, and if the documents are forwarded or if the waiver is sought, the presenter is precluded from objecting to the discrepancies notified to it by the issuer. The issuer is not relieved from examining the presentation under these rules. The issuer is not obligated to waive the discrepancy even if the applicant waives it, and the issuer must hold the documents until it receives a response from the applicant or is requested by the presenter to return the documents, and if the issuer receives no such response or request within 10 business days of its notice of dishonor, it may return the documents to the presenter. Disposition of documents. Dishonored documents must be returned, held or disposed of as reasonably instructed by the presenter. Failure to give notice of the disposition of documents in the notice of dishonor does not preclude the issuer from asserting any defense otherwise available to it against honor. Cover instructions, transmittal letter. Instructions accompanying a presentation made under a standby may be relied on to the extent that they are not contrary to the terms or conditions of the standby, the demand, or these rules. Representations made by a nominated person accompanying a presentation may be relied upon to the extent that they are not contrary to the terms or conditions of standby or these rules. Notwithstanding receipt of instructions, an issuer or nominated person may pay, give notice, return the documents, or otherwise deal directly with the presenter. A statement in the cover letter that the documents are discrepant does not relieve the issuer from examining the presentation of non-compliance. Applicant's notice of objection. An applicant must timely object to the issuer's honor of non-complying presentation by giving timely notice by prompt means. An applicant acts timely if it objects to discrepancies by sending a notice to the issuer stating the discrepancies on which the objection is based within a time after the applicant's receipt of the documents, which is not unreasonable. Failure to give a timely notice of objection by prompt means precludes assertion by the applicant against the issuer of any discrepancies or other matter apparent on the face of the documents received by the applicant, but does not preclude assertion of that objection to any different presentation under the same or a different standby.